Good morning. Welcome to DMH Stallard's first webinar of 2021. Today I'm Simon Bellum. I'm joined by Rustam Tata, and we'll be looking at the contract of employment and how that can be used to protect your business. I think it is incredible how often when we're consulted about a query, our first question is, well, what does the contract of employment say? And that kind of underlines the importance of trying to make sure you get your contract right. So that's what we'll be looking at. A few things by way of housekeeping, first of all. At the bottom of your screen, there should be two buttons. There should be a chat button and a Q&A button. The chat button is if you've got any technical problems, if you can't hear us or whatever, and we'll do our best to get that sorted out. The Q&A button is obviously if you've got any questions about the subject matter that we're talking about. And what we'll try and do is respond to those questions either during the webinar or at the end. And after the webinar, we'll prepare some follow-up material, which will include the slides and the recording, and also all the questions that have been asked with our best attempt at answering them. Okay, so I'm going to look at the situation before the employment starts, and what we're going to do is we're going to just go through the timeline of an employment relationship. I'll look at some interests that you're trying to protect before the employment actually starts and what you're worrying about then. Then Rustam's going to have a look at what you'll be worrying about once the employment gets underway. I'll look at some ongoing risks that exist throughout the employment relationship and making sure that the business is protected. And then Rustam is going to round off by looking at some of the things you want to protect at the end of the contract of employment. So let's kick off and look at before the employment starts. What will your main concerns be? Well, typically, your main concern will be to make sure that the employee turns up, they start on time, and they get up and running. And how can we use the contract of employment and the contractual documentation generally to make sure that that happens? Well, we've probably all been in a position where the employee changes their mind. So we've made an offer of employment, which has been accepted. And for some reason, the employee changes their mind and doesn't show up. A normal position there is that if the employee has signed a contract of employment committing to start on a particular date, then their failure to turn up and work will be a breach of contract. But what can the employer do about it? And typically not very much, because whilst the employer could bring a breach of contract claim, the value of that claim is likely to be very low. It's going to be limited to the employee's notice period. And when you work out, well, what's the employer lost? The employer has lost the value of the employee's services. How do you put a monetary figure to that value? Well, typically it will be the salary that the employee would have been paid. So you find yourselves in a situation where the employer's loss is wiped out by the fact that they will have saved on the salary. So the employer has no claim. And there's possible theoretical claims for lost opportunity on the part of the employer, or for the employer's additional cost of hiring a replacement. But those sorts of claims are difficult to establish. There is, however, one possibility, and it's useful in particular with very senior employees, and that is to use a no-show clause. A no-show clause is a clause which specifies that if the employee does fail to turn up, then the employer will be entitled to a specific sum of money, which truly reflects the employer's loss. And that sum of money is called liquidated damages. And typically the figure would run into the thousands, if not the tens of thousands of pounds. So what are the requirements of a no-show clause? Well, first of all, it needs to be part of a contract that the employee has entered into in order for it to be enforceable. The liquidated damages, the figure that the employee has to pay if they don't turn up, mustn't be a penalty. So it must be a reasonable and genuine estimate of the employer's loss that arises as a result of the employee's no-show. In terms of enforceability, it will help if the losses of the employer are made clear to the employee in advance. So the employer says, well, look, you need to be aware that we're relying on you to turn up on a particular date. We've got various business opportunities that you're going to be involved in from day one. This is the potential value of those opportunities. Your attendance is critical. If you fail to show, then this is what we're going to be losing. And it will help if the employee has taken legal advice. So no-show clause is likely to be relevant for senior employees, where if they don't show up, there'll be a significant loss. And another reason for including them is that if you have got a very senior appointment, and if the clause is included in the contract and the employee is reluctant to agree to the clause, might it make you suspicious as to the employee's commitment? A second scenario, this is where the employer changes their mind. So you've entered into a contract with the employee that they're going to start on a particular date, and for some reason or another, you as the employer decide, well, we've got to change our mind and we can't go through with this employment. Well, again, the normal position is that there's a breach of contract, and the employee will be entitled to be compensated in respect to that breach of contract. And typically they'll be entitled to their earnings that they would have received during their notice period. What could you do to reduce your liabilities and reduce your risk of that happening? Well, a number of possibilities. One obvious thing to do is to have shorter periods during the initial period of employment, and that may naturally arise if you've got a probationary period. You know, typically during probationary periods, the employment can be terminated by a shorter period of notice. So therefore, your liability as an employer will be reduced because the notice period is short. Another possibility is to make sure that you're not actually in breach of contract in the first place. So if you are carrying out pre-employment checks and the employee's failure to satisfactorily complete those checks or get satisfactory responses to the checks is why you can't go ahead with the employment, then provided you've made it clear that the offer of employment is conditional on the employer being satisfied as to the responses, there will be no breach of contract and therefore no liability. So you've got to be very clear in your offer letter, what are the conditions that need to be satisfied in order for the employment to go ahead. And if you're doing that, I would encourage you to set a time limit for responses to those checks. So simply so that you discover any problems sooner rather than later. And quite often timescales are short, people are in a bit of a rush, there's a delay in getting the responses and you're left in limbo, as it were. So I'd always put a time limit. So one particular area which can crop up is in relation to health issues. And I thought it was worth just looking specifically about how an employer can cover this off when it's offering employment. Well, the first point to make is that, as you're probably all aware, under the Equality Act, an employer's got to be very careful about the questions it asks regarding an applicant's health before they offer work. Basically, it's unlawful to ask an employee about their health before offering work to them. However, the EHRC guidance is clear that once you've decided that you're going to offer somebody work, you can make the job offer conditional on satisfactory responses to questions relating to disability or health inquiries or health checks. So clearly there is that opportunity to say, well, your employment and this offer of employment is conditional on X, Y, and Z. What happens when you do get a response that causes you concern? Well, there you have to look at the next piece of the guidance, which is that, okay, you've got a response which indicates that there is a potential health issue. It emphasizes the importance that you mustn't discriminate against the employee on the back of the results of those inquiries. So if the response indicates that the applicant stroke employee suffers from a disability, then you've got to do your thinking in terms of reasonable adjustments, etc., and make sure you don't discriminate. But the point is that an offer of employment can be made conditional on satisfactory responses. I'm going to look at a different area, and that's the right to work. A few things just to make sure you've got in place in relation to offering jobs and your contracts. Do your right to work checks before the employment starts. That's a requirement. If the offer of employment is conditional on immigration approval or a specific working visa, make sure that the offer is conditional on that approval being obtained. Possibly include flexibility in the start date. That goes back to sometimes the problems in terms of timings, so that you make it clear that in the event that approval hasn't been received by the anticipated start date, then that's going to be put back. And include a warranty in the contract of employment. That's effectively a promise on the part of the employee that they have the right to work, because that pushes some of the burden onto the employee in terms of the potential liabilities that arise. Next thing is freedom to work. In certain circumstances, an employee may not be free to work for you. A typical example is if they are subject to a restrictive covenant as part of their previous employment. It's possible that there might be some statutory prohibition on them working in your particular sector. So include a warranty promise in the contract of employment, whereby the employee confirms that they won't be in breach of any court order or contractual obligation if they work for you. And that will reduce the risk that you will be liable if it turns out that the employee is in fact subject to a restriction. Next area, which can be a potential hurdle, is the question of qualifications. Include in your contract of employment a warranty that the employee possesses any necessary qualification to carry out their role, and that they'll maintain that qualification or registration. And it could be something as simple as a driving license, that they've got a driving license which will enable them to do that part of their job. Or it could be the possession of a professional qualification, such as registration as a nurse or a doctor. A number of reasons for having that contractual promise in the contract of employment. It helps to make sure that the employee is adequately equipped and qualified for the role, and it massively reduces the risk from the employer's perspective if the employee is subsequently found not to be properly qualified. It's important as part of that warranty that you require that the employee declares if they should lose their qualification or registration. I've had a couple of examples relatively recently where one was where a nurse lost the registration, and for a short period of time, it was because they'd failed to complete some mandatory training. For a short period of time, they were not registered as a nurse, even though they were fulfilling the role, and that created all sorts of potential liabilities for the employer. And the other one was as simple as a driving license. An employee who was a salesperson lost their driving license, didn't tell the employer about it, and carried on attending business appointments using public transport, which obviously wasn't very efficient or effective. And when the employer said, well, look, you've been dishonest, you haven't told us about the loss of your driving license, the employee turned around and said, well, I wasn't under any obligation to do so. And the employer was in some difficulty. So, just a few tips there in terms of the contractual arrangements before the employment starts. I'm going to pass over now to Rustam, and he's going to look at some of the issues once the employment begins to get underway.
Thanks very much, Simon, for setting the scene there for us. So I'm going to start off now this morning with looking at probationary periods. And we've got a poll for you. So if you use probationary periods, how useful do you think they are in focusing line managers in identifying poor performers or inappropriate hires? So if you could click on the answer that you think is most appropriate to you. And then I think in a moment we'll probably close it and see what responses we have. Thank you very much, Amber. So there we are. Overwhelming majority use them in some way. About a third of you say you think they're very useful. But it's fair to say by more than 2 to 1, the view is it's around the quality of the line manager and monitoring performance. And I guess that's probably not sort of too much of a surprise, and probably confirms our experience as well. So if we're thinking about the probationary period then in the contract of employment, one initial question that comes up is sort of how long should it be? Well, there's no magic answer to that. I think it's fair to say that at the moment, probably most probationary periods tend to be either 3 or 6 months. Occasionally, we might see 12 months as a probationary period, but I think, as I said, I think that would be relatively exceptional. What assessment tools do you use? And this obviously sort of goes back to the poll. I think in part the probationary periods needs to be long enough so that you can make a meaningful assessment. Maybe it's stating the obvious, but making a meaningful assessment of that employee, and sometimes the role that they do means it will take some time before they properly get going. It may be a role where the individual has to undertake a considerable amount of training before they, as it were, get involved in dealing with actual issues. Now, if that training is going to take a period of 6 or maybe 8 weeks, you can see that 3 months probably isn't long enough, because you won't have had a proper opportunity to assess how effective they are. I think another question again is, how do we make sure that there is some sort of effective monitoring? What's the quality of that information and evidence? And what do you do, for instance, the old chestnut that performance might be in some way being impacted by a health condition, and the health condition of course needs some consideration, some exploration, and it may be of course that the health condition itself is a disability. Now in that situation, it's very likely that you would want to be able to extend the probationary period. So it's not a completely binary, either you pass the probationary or you don't. We might need the third option of being able to extend the probationary period. And then perhaps the question arises, for how much longer should the probationary period be extended by? What, if any, conditions are there that will attach to that? I think one critical thing, as well as thinking about the duration, the ability to extend it is making clear in the contractual wording that if you say it's subject to satisfactory completion, again, seen this argued so many times, whose satisfaction is it that has to be met? I think you need to make clear, it's a little bit like with references, that it is the employer's satisfaction. So I think those are some of the key things to think about. The other thing, of course, in the context of that probationary period is how long should the notice be during the probationary period? And again, I think you have to work very carefully on the contractual wording to make sure that, for instance, if the probationary period expires and maybe somebody's missed it, does that automatically mean the employee is entitled to longer notice? And what about if there's an extension to the probationary period? What happens in relation to the notice period there? So yeah, just a little bit of careful work around those probationary periods. I think then we look at the suitability or capability of the individual in the role, and then we've sort of got the ongoing performance management. And I think it's probably fair to say that this is an area that nearly every employer struggles with one way or another. I know without giving anything away that probably as a firm we struggle with it a little bit. It's that piece around trying to make sure that the individual is working effectively, and that, as it were, you pick up the warning signs early enough if perhaps there are shortcomings in the performance, and that's addressed obviously in an effective and meaningful way. So there will be issues in most cases, I think, around the actual sort of collecting and retaining of that meaningful data, that there is a proper assessment, that it's not a little bit just too anecdotal, because again, my experience, and this isn't just in my firm, employees generally rail if they're taken to task over instances of poor performance, and either try and say, well, it was a one-off, and very often as the employer, it's going to be important to show something of a pattern, unfortunately, or that there is that sort of consistent poor performance or underperformance. And then, as I flagged earlier on in the context of probationary periods, I think what we've found increasingly over the last few years is that when you then do try and sit down with an employee and look at performance, health very often, probably more often than not, is an issue. And then we're very often looking and saying, well, do we need to get some sort of occupational health input? A whole separate question about finding effective occupational health advisors and getting meaningful reports, but we probably want some input there. That then raises, of course, GDPR and access to medical records issues. So just being clear about what data we're seeking, why we're seeking it, and then obviously the conditions in which that data is held and who it's reviewed by, and managing, as I say, sort of poor performance where there's an ill health element is probably one of the most tricky areas, and certainly sometimes one of the most time consuming and sometimes frustrating for employers. So in the context of the contract, obviously we would want to make sure that there's clear provision that we can require the employee to undertake or undergo an occupational health assessment. Obviously they can refuse, but it then gives us the ability to say, well, you know, we've got a problem here with performance. We're prepared to look at the health side of things. You're not cooperating, and potentially we move ourselves either into a conduct dismissal or into some other substantial reason dismissal territory. So I think that ability to be able to do that is important. I've put there on this slide then at the bottom, ensuring that the individual has clear focus on the work of the organisation, and this would be clauses perhaps around their working time, and ensuring that there's a focus during working time, that the sole focus is the employer's interests and business. Got a case at the moment, and it's probably something for our time where you've got an employee that's working remotely because of COVID, and it turns out that she hasn't been particularly engaged in the work of the client. She's been making mistakes. Other people in the team are getting a bit frustrated. Her attendance on Teams is a bit haphazard. She first of all says, oh, it's because I've got all these medical conditions. The occupational health report is inconclusive, but we've subsequently found out she's involved in 3 or 4 other businesses that she's running through Facebook, etc., on the side, which would explain why she's not giving her full attention to our work during the working day. So fortunately there we've got some clear express provisions in the contract for the focus that she's supposed to place. So it's both during working time, and we might also have some provisions about external interests, regulating or limiting what those external interests are, or maybe at least notifying us of those. So developing that theme a little bit more, when we say a focus on the business, say it might be both while the individual is working, as well as to some degree perhaps when they're not working. So we've talked about the whole working time and attention, paying attention as it were to the employer's business and not being distracted or diverted by other things. We might also have an express provision saying that the employee owes an obligation of good faith to further the employer's interests, and that can be quite a helpful clause. We might also be looking at a code of conduct or behaviour that's expected of employees, and again that will very often cross over between both activities during working hours and then similarly what they're expected to do or not expected to do outside of working hours, and how perhaps their behaviour might reflect on the employer, the employer's organisation, on its interests, and possibly, of course, even on other employee staff. And the next area, which I suppose comes up every so often, obviously we had it with McDonald's a couple of years ago, the issue of relationships with and between colleagues, and the extent to which contractually we might seek to have a policy or we might seek to have provisions about how those relationships are to be dealt with, how they're to be reported, and then how it's to be managed within the workplace. And then finally, in this section, we might place a positive duty on employees to notify of possible conflicts. So personal conflicts of, as it were, of interest with that of the business, and in some circumstances, that obligation to notify of conflicts might actually potentially extend even to family members. Obviously, there's a tricky balance to strike there, but it is something something to think about. So now moving on to another area during the employment relationship. This is about training. So poll for you: if you enter into training agreements requiring repayment of costs when the individual leaves, how often do you recover money from the employee? We've got some options there. Be very interested to see what the responses are to this one. So do we nearly always, about half the time, around about a quarter of the time, or either we rarely use them or we don't recover money? Thank you very much, Amber. So, well, this is interesting, isn't it? Nearly half of the people are saying nearly always they will recover the money, and then around 20%, about half the time, or not very often. So it's clearly something that many people are using. I guess looking at the sort of return on investment for training, I think a lot of employers would have a separate training agreement, and I think that is helpful and important, not least because it should mean that we can avoid issues around the unlawful deduction from wages legislation there, because obviously otherwise we couldn't ordinarily deduct the money from salary perhaps when somebody is leaving. So a separate written agreement signed by the employee clearly setting out the amounts and the basis of recovery is helpful and important. And when I say the basis of recovery, that's the sort of basis of calculation. How is that to be assessed? I think in many cases now, employers tend to operate something of a sort of sliding scale, so that the percentage that's recovered reduces over time. And part of the reason, or the two reasons probably for that, one is that employees are probably more likely to agree to it. It sort of looks and feels fair. And the second is it hopefully avoids the risk of the recovery of the training cost being argued by the employee otherwise to be a penalty. And Simon touched on the edge of this previously when he was saying, what if the employee failed, the no-show clauses, failing to come to start the employment. It's very important that the employer isn't seen to be imposing what's termed a penalty on the employee. There has to be some sort of genuine pre-estimate of the loss. So obviously the value of the training from the employer's point of view probably reduces over time, and therefore that sliding scale is probably a sensible approach. Now, having said that, I do think that these can still be problematic in their application. Again, I think we fairly regularly are trying to advise employers where employees are arguing that the training costs shouldn't be recovered, that it's unfair, that it's a penalty clause, that it be an unlawful deduction. And even I've seen arguments raising issues around consumer credit and other regulation. So it is actually quite a difficult and tricky area. And it's fair to say that sometimes employers, if they're arguing about 500 quid, sort of will give up. Having said that, most employers would say, well, it's one of those areas where it's still helpful to have some documentation in and some expectation that there should be repayments, and it may at least discourage the employee from perhaps leaving a little bit sooner. They may look for the next step down, as it were, in terms of what might need to be repaid. And then just finally on this section, a reminder, of course, that the changes to Section 1 statements that came into force last year require employers to provide to provide specifics about training that employees are required to undertake, either as a precondition or during their employment. That's something now that has to go in the Section 1 statement, and as I'm sure you all know, the Section 1 statement now essentially has to be given on or before the first day of employment. It's no longer good enough to wait for the first month. So I pass back to Simon. Simon, I don't know, we've got any questions just to see how we're getting on at the minute.
We've got some some very good questions. There are a couple about the health questions that might be asked when you're offering a position. So Sarah's asked, have you got an example of where a response to a health question might not be satisfactory, especially in an office environment? I'm struggling to see the point of asking the question as it feels as though it's just too risky. And that's linked, I think, to a second question from an anonymous attendee. If an employee does not declare dyslexia and a history of anxiety and depression, brackets long-term medication, on their medical questionnaire, and following successful completion of their probation period, their performance declines to the point that colleagues have no confidence in her, does this complicate the capability process? So the first question is it worth having the health questions there? Because, you know, when might you get an answer, particularly in an office environment, which will make a difference, and it's risky. I agree with the point that you have to, in terms of it being risky, you have to be careful about how you ask the questions. And I would generally speaking say, only ask questions if they're relevant to the particular role. Okay, what might be relevant in an office environment? Well, there is an example that springs straight away to mind because I'm dealing with the situation at the moment on behalf of a client. That's a situation where the employees needs an assistant to carry out their role. So because of a disability, the employee needs support from an additional employee to help them carry out their role. Now that begs all sorts of questions in terms of how the employer then responds to the situation, but it kind of identifies the reason why sometimes there will be an answer that is really important for the employer to know, because at that point the employer has to think very hard about, okay, well, how are we going to respond to this? You know, due to make reasonable adjustments, what sort of obligations does that impose on us? And then the second question was, well, suppose somebody hasn't declared on their medical questionnaire that they've got these serious medical issues which amount to a disability. They complete probation successfully, but then performance declines. Does that complicate the capability process? Well, I think the two things to pick out from there are, one, the dishonesty on the medical questionnaire. They didn't disclose it. Now, that's a tricky one. Yeah, what can an employer do about that? Well, the guidance isn't very helpful. What the guidance says is that employees should declare disabilities. It doesn't go as far as saying if they don't, then the employer is entitled to regard that as dishonest and is entitled to take some form of disciplinary action. So my advice to an employer in that situation is be very careful before you start relying upon the non-disclosure to take any action against the employee. In terms of how it affects the capability process, well, if you've got somebody who's disabled, then yes, it will affect how you go about the capability process. You need, in particular, to consider reasonable adjustments, and you need to consider the fact that if you do discipline somebody or subject them to a capability process and they're disabled, then if the reason that you're doing that arises as a consequence of their disability, then you need to make sure that your actions as an employer are justified. And then a quick one for Ruston from Rachel. Probationary period. What if they do the job well but are rude to colleagues?
Well, if the rudeness is substantial enough, I would be saying that, and if the colleagues are upset by it, I personally would say that is too disruptive of the team, and that's really a ground to bring the relationship to an end. Of course, they won't have unfair dismissal rights, but I appreciate that they will probably identify a protected characteristic of some sort or another and try and use that. So I think it's really a question of looking at the substance of the rudeness and the impact on the colleagues, as well as, of course, the environment generally. I mean, there'll be probably different standards expected in different organisations and sectors. But I think having a new person coming in, upsetting the existing team, if their behaviour is sort of blameworthy or is wrong in some way, then I think that's absolutely the right thing to do, to frankly to move them on.
Okay, thanks, Rustam. Well, some terrific questions there. Thank you very much. I'm going to carry on now and look at some of the ongoing risks during the employment relationship and look at some specific areas. The first thing that I'll look at is how we protect the business in terms of intellectual property. Now, what is intellectual property? And you can see from the list that it will include trade secrets, ideas, innovations and inventions, copyright, photos, design, styles, names and brands. So it's that type of thing. It's ideas and particular types of image, etc., that we're trying to protect. So looking first at the employer's intellectual property, how do we make sure that that is protected and that an employee can't misuse it and damage the business? And the obvious way is to use a confidentiality clause. And it's worth having an express clause because the implied duty to maintain confidentiality is pretty limited. It probably only exists during the currency of the employment, unless the information that you're trying to protect is genuinely a trade secret. So it, as I say, offers the implied term offers the employer limited protection. So you need an express clause that will extend the protection beyond the end of the employment, and it will also remove any doubt or argument about whether information is protected as confidential. So the clause identifies clearly what information is regarded as confidential and is therefore protected. It will include an obligation not to use the information or disclose the information to a third party. And it should be broad enough to cover any confidential information which belongs to your customers or your clients that might come into the employee's possession. So you're protecting your clients and your customers and your relationships with them, as well as your own intellectual property. Next, we'll look at the employee's intellectual property. And what I'm thinking about here is where an employee comes up with an idea or a brand or a design that you want to be able to take advantage of and to use, and you don't want to have an argument as to who owns those intellectual property rights. And the general position is that an employer will be the owner of intellectual property that's created by an employee during the employee's employment. Position in relation to inventions is a little bit more complicated, but generally under the Patents Act, inventions made by an employee will generally belong to the employer if they're made in the course of normal duties. And the area which causes the greatest dispute is where there's an argument about whether or not an invention has been developed in the course of an employee's duties. So it's sensible to include an express clause to make it clear that all intellectual property which is developed whilst the individual is an employee belongs to the employer, whether it was developed during the course of them doing their work, whether it was developed in the evening, in the garden shed, or whatever. So what the intellectual property clause will say is that the employee will hand over details of any intellectual property right that they have, any ideas, inventions, etc. They pass over information to the employer. They won't attempt to register it in their own name. They won't disclose it to third parties. They'll keep it confidential. They'll waive their own rights in relation to the intellectual property. They'll pass over those rights to the employer. And indeed, if there are any third parties who try to argue with the employer about the intellectual property rights, they will assist the employer in defending those third party claims. What about the employer's reputation? I think that this is a real interest of most employers that needs protecting properly. And there are a number of possibilities. So the first thing would be to use your contract of employment to have a general duty on the part of the employee not to bring the employer into disrepute. And you can expand upon that. You can have more specific duties, such as a duty not to make a public comment or not to make public comment without the employer's permission, so that you make sure that your employer is thinking hard about the employer's reputation before they start discussing matters in public. Another possibility is to look at, if we look at the next slide, the risks that arise from social media. Now, clearly in this day and age, there are real risks that arise to most employers as a result of employee use of social media. It might be a question of the employee being critical of the employer through social media. It could be that the employee is posting stuff which doesn't have any connection with the employer or doesn't relate to the employer's business, but it reflects badly on the employer because other people will know that that individual is employed by you. So you may well want to control how your staff use social media. There is a bit of a balance that's needed here. We need to balance the interest that you have as an employer in terms of protecting your reputation with the employee's desire to use social media and to have a level of freedom. But I think the important thing is that the social media policy defines clearly what is and isn't allowed, and it makes it clear to the employee that their use of social media, even if it's done during their own time in the evenings, etc., can affect the employer, and the employer has a right to say this is allowed and this isn't allowed. Make sure that if an employee does use social media as part of their work, that you're clear about what the employee can and can't do, what they can and can't say, the limits of their discretion. And as well as protecting your reputation, having an effective social media policy should help to protect your intellectual property, to make sure it's not shared through social media, and will help you avoid liability for claims of defamation or discrimination, harassment, if an employee is daft enough to put abusive material out there on social media about individuals. Then, last area in relation to reputation is anti-bribery. So normally a contract of employment will include a provision that the employee won't be involved in any form of tax evasion, bribery or corruption, and that they'll report any concerns or approaches that are made to them. And that simply helps, first of all, protect your reputation, and also helps you to comply with the legislation relating to tax avoidance and bribery. Looking at a different thing that you'll want to be looking after, and that's your IT systems and the integrity of your IT processes. Now, why might you need to have this in place? Well, you'll want to protect unauthorized disclosure of confidential information. It will help to prevent third-party intellectual property rights being infringed. It will help to prevent the harassment of employees. It will help to protect again against reputational damage. It helps reduce time wasting and lost productivity, and it will help protect your IT systems. So what might a IT usage policy include and cover? So it will be clear about equipment security and passwords. It will be clear about systems and data security. So for example, it will say you mustn't download third-party software. It will cover email use, internet use, covering illicit use of the internet, personal use of the employer's systems, making sure that the employer's systems are used for what they were designed for. It should also cover monitoring, so that if you've got concerns, you're able to monitor an employee's usage of your IT systems and it will cover prohibited use. So it will say, well, look, it's not to be used for this purpose or that purpose. Another thing that you'll want to be protecting during the employment is the situation where something is being done within your business which might be unlawful. It could be criminal activity, it could be a breach of health and safety regulations, it could be an employee who is failing to comply with their own contractual obligations, they're working illicitly for somebody else. The surprising thing is that there's a very limited implied duty on the part of an employee to disclose their own wrongdoing. Generally speaking, it will only be senior employees who have any form of implied duty to disclose to the employer if they're doing something which is wrong. There's no obligation on the part of an employee to disclose the wrongdoing of colleagues. So that's why it's sensible to include within the contract of employment an express duty on the part of the employee to disclose both their own wrongdoing and the wrongdoing of others as soon as they become aware of it. It just makes sure that where things are going wrong, they're brought to the employer's attention as quickly as possible. The other way of doing that is obviously to have a whistleblowing policy. There's no general obligation to have a whistleblowing policy, but there are lots of good reasons why you ought to have one. Compliance and internal control. It makes sure that employees can raise issues such as the ones I've described, and they are encouraged to raise those issues. So if somebody is ignoring health and safety regulations, doing something dangerous in the workplace, then a whistleblowing policy will help make sure that that is brought to the surface and you're able to address it without the regulators getting involved and reducing the risk of reputational damage. If you've got a whistleblowing policy, it helps to encourage employees to raise issues with you rather than going to the press, for example, because if they go straight to the press rather than to you, then they're less likely to have the protection of the whistleblowing legislation. And then it will help you avoid criminal liabilities in respect of bribery and tax evasion. It's an important part of compliance with slavery and human trafficking obligations. And in certain sectors, it's a requirement that you should have a whistleblowing policy, particularly in terms of financial sectors, and if you are part of a PLC. Okay, so those are some of the things to be looking at whilst the employment's ongoing. Rustam's going to round off by having a look at some of the issues and some things you will want to protect at the end of the employment.
Brilliant, thank you, Simon, and covered obviously a lot of ground there, looking at bribery and whistleblowing. So at the end of the employment, poll for you again. Which of you include restrictive covenants for staff below director level? Thanks very much, Amber. So there are about 1 in 6 of you just have general covenants for everybody. Around about a third that apply to everyone. A quarter only around certain functions, and about 1 in 5 saying we don't really bother with them. I don't think there's an absolute right or wrong answer here, and there will of course be some sectors where it's more appropriate and they'll be more involved. But an allied question is, how often do you get involved with reminding departing employees of the restraints to which they're subject? Just got 3 options there. We do it as a matter of course, it comes up, a handful of times a year, or we don't really bother. Thanks again, Amber. So there we are, 2 in 5, so 40% saying we do it as a matter of course, about another 30% saying comes up a handful of times, and again just under a third saying we don't sort of bother at all. But as I was saying, it's probably slightly a question of kind of horses for courses, but I think it's probably helpful just to remind ourselves of some of the sort of basics and principles in relation to post-termination restrictions. So the classic areas where you'll want to regulate that post-termination behaviour by a member of staff will be around colleagues, it'll be around customers, it'll be around possibly suppliers, and it might be around other trade connections. There's probably one other area which is confidential information, which I'll come on to a little bit later on. So when we're looking at restrictive covenants, we really need to start from the point of what is it potentially that's capable of protection, because courts will generally say that a restriction on somebody's activities after they've left you is potentially a restraint of trade. That's the starting point. And so it's necessary for the employer that is seeking to rely on a post-termination restriction, ultimately to be able to satisfy a court that the restriction is no broader than is reasonably necessary to protect a legitimate business interest. So then we say, okay, well, what are the things that are capable of protection? What are those interests? Well, as I said on the first slide, very often it'll be maintaining the loyalty of a customer base. Maybe it will be ensuring that you have a stable workforce. Maybe it'll be ensuring that your supply chain is not unduly disrupted. And there's a tricky balance here, because generally speaking, courts won't prevent simple competition. So just saying we don't want you to compete with us on its own is usually quite difficult to be able to enforce. Usually you have to be able to show that something else is being disrupted, as I say, maybe your workforce because people are coming and tapping up your staff to join them, or maybe it's existing customers. We'll need to look at and think about duration. So how long should the restriction be? And again, in the whole area of restrictive covenants, it's an art, not a science, and therefore there is no magic period. Generally speaking, 12 months is as much as we might be able to achieve by way of restriction, but there will be some sectors where even 12 months will be a little bit high, and it might be tricky to be able to get a restriction for that length. For many years, the issue of geography was said to be critical. It's probably fair to say that over the last 20 or 30 years, with so many organisations and businesses and so much of what is supplied being no longer done on a local basis, but on a national or a global basis, that geography has probably become less of an issue in most post-termination restrictions. The actual sort of scope and extent of what is covered in terms of the behaviour. So it would be one thing saying you can't act for a customer of ours, or you can't do some work for them. It might be different, obviously, if you're saying, well, you can't go and tout for their business, you can't actively go and seek it. And similarly with staff, obviously you could potentially have a restriction saying simply you won't employ a colleague for a period, or you might have a different restriction talking also about that you won't actively seek to employ them or go and try and recruit them. I think what's really important in the context of post-termination restrictions is to ensure that the provisions are tailored. And this is where it, to be honest, it is problematic. In an ideal world, one would have tailored post-termination restrictions for different groups and categories of employees, rather than have a single set that applies, as it were, across the board. And the argument, of course, is that those different employees at different levels in different areas of the operation will, if you like, what's sensitive and what you want to protect or what you need to protect and what it's reasonable for you to seek to protect is likely to be different with different employees. Now, having said that, I know it's still relatively unusual for the restrictions to reflect perhaps seniority or to reflect different areas of work, but it is something to think about. I think when we're thinking about post-termination behaviour and post-termination restrictions, we very much need to bear in mind the sort of commercial effectiveness point. And I guess there are two real things to think about here. The first is that people tend to either simply to say, oh, all post-termination restrictions are unenforceable, and literally try and ignore them altogether. I'm helping a broking client, an insurance broker client at the moment, and they've got a new individual who basically says, yes, well, I know I signed these things, but it's nothing to do with me. I should be able to do everything that I like. And of course, it's not as straightforward as that. But the second thing is probably what you ideally want as the employer or as the former employer, for your employee to look at the restrictions and maybe get some legal advice, and maybe even the new employer look at the restrictions and say, we can see that we can't simply dismiss them out of hand as being unenforceable. We can see that there are certain points which are potentially enforceable, because what that will do is it will potentially limit or restrict the activities of the employee for a period. They will perhaps kind of try and be a bit more under the radar. And that, of course, is exactly what you as the former employer want to achieve. You want to try and achieve a period of relative stability with your staff, with your customers, with your suppliers, and with your sort of trade connections, referrers and others generally, so that you can as it were, settle things down after the particular employee has left. I think one point just to think about here again is that interplay with other terms. So we might have a 6 or a 9 month post-termination restriction, but is that the best way to get the protection that we want? And in some situations, it'll be much more appropriate to think about notice periods and the length of the notice period, and also to consider garden leave during the notice period. So yes, it means the employer is having to pay, but because the employment relationship is continuing, the degree of control that can be exercised over the employee and the degree of restriction is much, much greater. Once they've left you, it's much harder, because you'll immediately face the argument, I'm no longer the employee and I say the post-termination restrictions are not effective. So it's a question of looking at that interplay. And finally, on this point, the government is looking at the whole issue of post-termination restrictions and whether or not they should be outlawed altogether, whether, for instance, employers should have to pay some or all of the base pay for the employee during the period of restriction. That's what happens in some continental countries, which seems to sort of work relatively well. The consultation is ongoing at the moment. I think it closes later on this month, and I would expect that later on this year we'll hear whether the government is deciding whether or not to bring forward legislation. So there is a bit of a watch this space on this point. And then finally, I mentioned confidentiality. Confidentiality and keeping confidential information confidential is a post-termination restriction. The reason why I've separated it out is it is not subject to any restriction in terms of is it reasonable or how long can it be, how long can it last for. If it's genuine confidential information, the employee must take that confidential information to their grave. So it is of a different type, and it can be very powerful for in certain circumstances for an employer to use that. Obviously, again, there's an interplay there with reputation management. Simon has touched on that, so I won't go over that again. I think confidentiality provisions do have something of a mixed effectiveness, because generally the employer, where there's breach, the employer will usually need to show financial harm of some sort or another, and enforcing them can be difficult. And similarly, Simon touched on whistleblowing, and here again there's a little bit of a standoff in terms of the employer saying, well, I've got this confidential information and these rights that need to be upheld, and the employee saying, well, I've got the entitlement to make a protected disclosure and whistleblow. And certainly we're seeing that whistleblowing legislation is being used and deployed by employees. Originally, it was meant to, of course, be a shield to protect employees, but we're increasingly seeing it being used as a sword by departing employees, arguing that they're entitled to disclose certain confidential information because it's a protected disclosure and it's under the whistleblowing legislation. So finally, how confident are you that your restrictive covenants are enforceable? Just a quick final poll. So are we very confident because we're successful in enforcing them on a regular basis? We're fairly confident, but we don't often need to deal with it. They're there for the for the sake of it, and we hope it has a bit of an impact. Or even after today, it's my least favourite area after TUPE and pensions. Terrific. Well, there we are. Most of you are fairly confident, but you don't often need to use them. So obviously that's good news. So I think that's my section done. So Simon, I'll just hand up to you, back to you for any final questions and close.
Yeah, thanks, Rustam. That's really, really interesting. Well, I'm conscious of the time, so I'm just going to round off by mentioning our next webinar and just dealing with one or two questions. So the next webinar is on the 11th of March. So get the date in your diary. We're going to be looking at IR35. So it's a reminder of everything that we were getting prepared for over a year ago, and to try and deal with some questions there. And we'll also be looking at the relevance of the Chancellor's budget to HR practitioners and employment lawyers. We've had some brilliant questions today. So one quick one is, lots of businesses are using Teams or Zoom to allow general chat between colleagues. Is it reasonable for a business to monitor that chat? My quick reaction to that is I would be very, very careful before you monitor it, because if the idea of general chat is to support collaboration, etc., to maintain the sort of sociability of working with other people, then I would be slow to monitor it. Debatable whether it's permissible to monitor it in any case. And last one, Rustam, to give you the final word about probationary periods.
Thanks, Simon, and thanks, Jonathan, for the question. I'm just trying to get my head around that quickly and read it. I think it's whether you compromise your position if during a probationary period you offer effectively a longer notice period. I think as long as you are very careful about how it's expressed and why that longer notice period is being given, I think you should be okay, is the short answer.
Okay, well, thanks very much, Rustam. Thank you very much for listening in. I hope you've enjoyed it, found it useful, and we look forward to seeing you on the 11th of March. Bye now.